navigate the health and social care.
Yes, Mr. Crowter.
Thank you, my Lord. In this appeal, I appear for the appellants with Mr. Quintavale, and Miss Smythe and Mr. Vanderman appear for the respondent. The papers that the court should have comprise core and supplementary bundles, an authorities bundle in 2 volumes, skeleton arguments from both parties, and a supplementary skeleton from both parties.
Yes, we have all of those, thank you.
In accordance with the law. With my apologies for not raising this matter with the court in advance, I wanted to ask the permission of the court for my client, the first appellant, to say a few words to introduce the appeal. She did so at the permission to appeal stage. I would have asked in advance, but our wires were crossed, I'm afraid, and I didn't.
It's a slightly unusual request, Mr. Croppell.
Yes.
I understand, obviously, the human background to this case, but it's the issues inevitably are legal issues. I think what we would prefer, I must say it would have been better if we had been asked first, would be when you come to the end of your submissions, if we would be very happy to hear briefly from your client at that point. I think that makes, frankly, more sense.
Yes.
And let's handle it in that way.
Thank you, my lord. So the appeal, as the court will have seen, is against the order of the Divisional Court of the 23rd of September 2021, dismissing the appellant's claim, which sought to challenge Section 11D of the Abortion Act 1967 as incompatible with their convention rights. The appeal is brought with permission of this court, granted on limited grounds on the 11th of March 2022. The court directed on that occasion that the appellant's permission to appeal skeleton should stand as the appeal skeleton, with the result that there is something of a mismatch in the ground covered by the parties' respective skeleton arguments. But just to be clear, in relation to my skeleton, there are 2 appellants, not 3 any longer, and the appeal is limited to Article 8, and Article 8 read with Article 14 of the Convention. Formerly grounds 2 to 5, now grounds 1 to 4, and what was formerly ground 6 on remedy was also refused permission, with the result that the relief sought is limited to a declaration of incompatibility. And we seek a declaration of incompatibility essentially for 2 reasons. Section 11D is perhaps conveniently to be found in paragraph 5 of the appellant's skeleton argument, where we set out Section 1 of the 1967 Act. And the 2 broad reasons which I'm going to advance today are, firstly, that Section 11D establishes legal grounds for abortion which are imprecise and subjective, which create an excessively broad discretion on the part of doctors and are not accompanied by any adequate safeguards on the exercise of that discretion. And so Section 11D, we say, is not in accordance with the law within Article 8.2. And secondly, we say that Section 11D is overly broad and disproportionate for that reason. It makes abortion available on grounds of disability right up to the very point of birth for a very wide range of conditions, regardless of whether the condition may be detected early in pregnancy and within, for example, the 24-week limit in Section 11A, regardless of whether the condition is curable or correctable after birth, and regardless of the stage of life at which the condition may manifest itself. The appellants rely, as the court will have seen, on Down syndrome as a powerful example of what they say is the overbreadth of section 1.1d. It is the most common ground for invocation of section 1.1d. A very high proportion of fetuses diagnosed with Down syndrome are aborted, yet it is detectable long before the 24-week cut-off in section 1.1a. Tests are available these days at 9 weeks and at 11 weeks. And in modern times, Down syndrome is not a barrier to living a happy and fulfilled existence, as Heidi and Hayden, the appellants themselves, demonstrate. And you have more detailed evidence of that in the first witness statement of Professor Jackson, paragraph 16 and 17, and in particular paragraph 25 on page 77 of the supplementary bundle. I shan't turn it up now, but what Professor Jackson explains in particular in paragraph 25 is that over the last 30 years there has been a radical change in the life prospects of people living with Down syndrome, largely as a result of more successful diagnosis and treatment of comorbidities. The effect of the Declaration of Incompatibility which we seek would of course be to require Parliament to reconsider the scope of section 1.1d, which it has not done for many years. There has been some more recent debate in the House of Lords, but the last vote in the House of Commons, as far as we can see, on the scope of section 1.1d was in 1990. A further debate and vote would take into account up-to-date social attitudes to disability, up-to-date terminology, and up-to-date science, as well as the United Kingdom's ratification of the UN Convention on the Rights of Persons with Disabilities in June 2009. This would not be a case of subverting the political process, as the respondent submits, paragraph 53 of his skeleton argument, but of inviting politicians to look again at the issue, and the political process will then take its course. So whilst we acknowledge that the issue of availability of abortion does raise certain moral and ethical issues, which the Divisional Court considered were entirely within the purview of Parliament, but we would emphasise that the Declaration of Incompatibility which we seek would not involve the court making any moral or ethical choices, which is within the province of the legislature. The in accordance with the law ground that we rely on involves no moral or ethical judgment at all. It's a purely legal question. And so far as the issue of justification and proportionality is concerned, we rely on what was said in the Supreme Court in the Northern Ireland Human Rights Commission case. Can I ask you to turn that up, please, for the first time? Bundle 1, tab 13. And page 377 of the bundle in the bottom right-hand corner, we have it's the speech of Lord Kerr, in the minority on the decisive standing issue in the case, in the majority on the compatibility issue. He cites in paragraph 300.
Formally, everything said on the compatibility issue is over to that,
yes,
right?
That's right. He, paragraph 300, quotes from the Supreme Court in Nicklinson, and at 344 of Nicklinson, what the courts do in making a declaration of incompatibility is to remit the issue to Parliament for a political decision informed by the court's view of the law the remission of the issue to Parliament does not involve the courts making a moral choice which is properly within the province of the democratically elected legislature. And then on page 300 of the same bundle, Lady Hale at paragraph 40, again in the minority on standing in the majority.
So sorry, which page?
Page 300 in the bottom right-hand corner.
Yes.
All paragraph 40, all that a declaration on incompatibility does, therefore, is place the ball in Parliament's court. And she then draws a distinction with Nicklinson, where a declaration was not made, in fact, on the grounds that the issue was already before Parliament. With that introduction, in my submissions today, I want first of all to spend a little time drawing attention to what we say are the key features and characteristics of section 11D, which then feed into the 4 grounds of appeal, and I will take then the 4 grounds of appeal in order. But by way of context and background, and to really to lay the ground for my submissions on the 4 grounds of appeal, I draw attention to the following features of section 11D.
Yes, just before we get into substance, have you spoken to Ms. Smythe about the allocation of time between the two of you?
We haven't spoken. I'm intending to finish by the end of the morning.
Well, that will leave plenty of time, because on the whole, the person going second has less ground to cover.
Yes, I know we did make this a slightly late start, but that's my
yes,
intention.
I'm sorry about that, but I think
No,
there were difficulties
Indeed.
getting everyone into court. Anyway, let's see how we go. That doesn't sound as though there's going to be a problem about time.
The court will find section 1 either in my skeleton argument paragraph 5 or in tab 2 of the authorities bundle, whichever is most convenient. The first point that we draw attention to is the effect of section 11D is that after 24 weeks, it is lawful to destroy a fetus which may be disabled, when to destroy a fetus which is not disabled would be punishable by life imprisonment, subject to the in extremis exceptions in 1B and 1C. And that is the result that submission follows from section 11A, which has the 24-week limit. Beyond that limit, an abortion may not be lawfully performed, subject to B and C, save unless D applies and there is a substantial risk that the child, if born, would suffer from such physical or mental abnormalities as to be seriously handicapped. Similarly, there is an offence of child destruction in the 1929 Act, which we haven't included in the bundle of authorities, but which
Is this all part of your first point?
Yes. Yeah. I'm sorry. So the point being, criminal offences would be committed in the case of an able-bodied fetus, but not in the case of a disabled fetus. See first of all section 1, and relatedly see the offence of child destruction, to which the divisional court refers in paragraph 14.
You're using the word disabled as a paraphrase for the actual words of the Act.
Yes. Okay. I'm not seeking to make any point on that.
It's not an entirely accurate paraphrase, is my point.
Well, my lord, one of the problems with the language used in the Act is my clients find it.
Well, that I can understand, and that's why I'm not pressing you to use the words of the Act, but we just need to note that disabled is not quite There's a different meaning in law from the words used in the Act.
Well, look, yes, and I'm not seeking to.
No,
make
okay,
any-
well that's fine. Keep going.
So the offence of child destruction set out in paragraph 14 of the Divisional Court's judgment, which applies to viable fetuses deemed from 28 weeks onwards, but section 5 of the 1967 Act disapplies the offence of child destruction, including in the case of section 11D, the disabled fetus. Secondly, my second point is, therefore, section 11D enshrines a very stark difference of treatment between disabled and non-disabled fetuses. A disabled fetus may be destroyed up to the moment of birth when no one seriously disputes that a fetus is a fully developed living being in all respects, save for its location at one end of the birth canal rather than the other, and when similar action in relation to a non-disabled fetus would be punishable by life imprisonment. So a very stark difference of treatment, we say. Thirdly, in contrast to the other subsections of section 1 of the 1967 Act, it is not a precondition for invoking section 11D that there is any risk at all to the physical or mental well-being of the pregnant woman or her family. That is a part of the preconditions for section 11A, section 11B and section 11C in their different ways. So within the 24-week period in section 11A, an abortion may in theory be refused because there is no evidence that it's necessary in the interests of the pregnant woman. But abortion would be permitted to the same woman if the fetus was disabled. Fourthly, there is no attempt in section 11D to tailor its effect to some conditions rather than others. There is no distinction drawn, for example, between fatal and non-fatal conditions. That has a legal significance because, as you will have seen, the Supreme Court in the Northern Ireland case held that there is an Article 8 right to abortion in the case of fetal abnormality, but not in the case of non-fatal fetal abnormality. There is no attempt, as there is under section 11A, to tailor the availability of abortion to a period within which it might be reasonable to expect that a decision may be taken, even in the case of conditions like Down syndrome, which are detectable early in pregnancy. Fifthly, the preconditions for invoking section 1...
Sorry, I'm not picking you up. I thought you said you had 4 points on 1D. This is a fifth one, is it? Maybe I'm missing that. It doesn't matter. I'd just like to keep my note clear.
No, my Lord, I don't think I said 4 points.
No problem. Keep going.
Point 5. The preconditions for invoking section 11D, substantial risk that the child, if born, would be seriously handicapped or would suffer from such physical or mental abnormalities as to be seriously handicapped, are not defined anywhere in the Abortion Act itself or in secondary legislation or in guidance issued by the defendant or any other government body. It is acknowledged by the respondent. I'll give you a reference, paragraph 14 of the witness statement of Professor Tillaghanathan at page 142 of the supplementary bundle.
Sorry, what was the page number again?
142.
Thank you.
It is acknowledged by the professor that the term seriously handicapped is outmoded or medical language. The claimants would go further, and in the witness statement of Ms. O'Sullivan of MENCAP, which is at page 412 of the supplementary bundle. I'll come back to this section and ask you to turn it up in due course, but Ms. O'Sullivan's position is that the language of section 11D is not only outmoded but is offensive and unacceptable to disabled persons. It is then left to the judgment of individual doctors to apply this outmoded, and we would say offensive, terminology without, as I will come on to explain, any significant oversight by the courts. Sixthly, the consequence of the breadth of section 1.1d is that there is scope for doctors, depending on their individual subjective views, to permit abortion under section 1.1d for conditions which may well be minor and even remediable, such as cleft lip or palate and club foot. Something of a debate in the evidence as to the prevalence of abortion for cleft palate, which is often cited as a minor condition for which section 1.1d permits abortion. Where it ends up, where that debate ends up, we say it's in two places. Mr. Argent, in his second witness statement, and again I'll just give you a reference, his second witness statement at paragraph 8 on page 219 of the supplementary bundle, citing from his personal experience, his long personal...
Can you give me the reference again?
Paragraph 8, page 219 of the supplementary bundle. And Mr. Argent's a former officer of BPAS and has long experience in the British Pregnancy Advisory Service, long experience in the abortion provision sector. He cites from his personal experience of doctors sanctioning abortion for cleft palate without there being any indication of anything more serious. And there was also evidence to that effect accepted by the Northern Ireland High Court. Again, I'll just give you the reference. Mr. Justice Horner in the High Court in the Human Rights Commission case, which is Bundle 1, Tab 12, paragraph 64 on page 246. Seventh point is that absent bad faith on the part of a doctor, which is a highly exceptional finding, and there's only one reported example in 50 years of the Act being in force, it is simply impossible for the courts to supervise or regulate the exercise of discretion by doctors, and there is no recorded...
When you say discretion, what do you mean by discretion? There's no discretion, they've got to apply the tests in the Act.
The discretion as to, in the application of the terminology.
They have to exercise a professional judgment, don't they?
happy to call it judgment, but in practice we say the breadth of the terminology gives a broad discretion to doctors when making those judgments, which is not capable of supervision by the courts. And my eighth and final point is on guidance. I've said already no statutory or even official guidance has been promulgated on section 11D. There is professional guidance or guidance from two professional bodies which highlights the breadth of the possible application of section 11D. The first and most important of those documents, I will ask you to turn up, if I may, page 221 of the supplementary bundle. Is the 2010 report of the Royal College of Obstetricians and Gynecologists. Termination of pregnancy for fetal abnormality in England, Scotland and Wales, report of a working party. And just to take you to a couple of extracts from this 227 in the executive summary. It says the report is intended to assist doctors and other health professionals to support women and their families when a fetal abnormality is diagnosed and to help women to decide within the constraints of the law whether or not to have the pregnancy terminated. It is designed to be explanatory rather than prescriptive and does not purport to give ethical guidance. And in the fourth paragraph down, there is no legal definition of substantial risk. Whether a risk will be regarded as substantial may vary with the seriousness and consequences of the likely disability. Likewise, no legal definition of serious handicap and assessment of the seriousness of fetal abnormality should be considered on a case-by-case basis, taking into account all available clinical information. And we highlight clinical information for a reason I'll come back to shortly. There is then a chapter of the report beginning on 237, dealing with the definition of substantial risk and serious handicap. And under substantial risk on 237, they repeat the point, there's no legal definition. And then in the second paragraph, they say it has been argued that since neither substantial risk nor serious handicap is defined, each can be interpreted on a largely subjective basis. As a result, it would be difficult, if not impossible, to demonstrate that a decision to terminate the pregnancy was not taken in good faith. And the footnote is to a book on medical ethics, Mason and McCall Smith on medical ethics. We understand that to be a positive endorsement of the view that it is that these terms can be interpreted on a largely subjective basis. That at least is we say what it would convey to the doctor reading it. But if it's not a positive endorsement, then it's not particularly helpful to set out what merely might be argued in one direction or another. Under serious handicap, there are some views expressed. they say in the third sentence of the paragraph under serious handicap, at a minimum it is suggested that a serious handicap would require the child to have physical or mental disability which would cause significant suffering or long-term impairment of their ability to function in society. The most serious genetic or other conditions which manifest themselves at birth or almost immediately thereafter are by and large likely to fall within the scope of section 11D, quoting Grubb on medical law. They then cite the Jepson case concerning cleft palate. And then on the following, on 238, there are some factors which they repeat from a 1996 report about halfway down the page on the scaling of severity of handicap, including potential for effective treatment, on the part of the child, probable degree of self-awareness, ability to communicate, suffering, probability of being able to live alone and be self-supportive as an adult.
So sorry, where are you reading?
I'm sorry, my Lord, I'm reading from 238.
Yes.
The list of factors about halfway down the page.
Yes, thank you.
Drawn from the 1996
Yes.
report. And then the final bullet point looks at the burden on society which the individual might pose on the part of society, the extent to which actions performed by individuals without disability that are essential for health would have to be provided by others. Then doctors are encouraged to consult appropriate clinical specialists. And then in the penultimate paragraph on that page, a further issue unresolved by the law concerns the time when the handicap will manifest itself. Children born with a correctable congenital abnormality such as diaphragmatic hernia may be deemed to be seriously handicapped until they receive effective surgical treatment. Pausing there, that is, as we understand it, an endorsement at least of it being a legitimate view that an abnormality may count as a serious handicap, even though it may be subject to effective surgical treatment. So until the point at which it is effectively treated. And then they say others suffering from a genetic condition such as Huntington's disease are unlikely to manifest the condition until later in life. And that then raises the question, and again we say, posits at least a legitimate view that a serious handicap may be a condition which will not manifest itself until considerably later in life, such as Huntington's disease. All depending on the judgment discretion of individual doctors. And in the conclusions, in the second bullet point, they say no legal definition of serious handicap, says 239, nor is it clear whether the disability has to be present at birth or will qualify if it's something that will afflict the child later in life. So we say the authors of what is the leading source of assistance for doctors are fairly acknowledging that there is real uncertainty as to the scope of the provisions, and leaving it to doctors to take these difficult decisions for themselves.
Yes, I mean, you have to look at the next bullet, which makes it clear the Working Party does not regard that as a problem.
Well,
because it believes it would be unrealistic to adopt a different approach where you had attempted a more precise definition or had a definitive list. I'm not arguing the point, I'm just saying that if you only look at that second bullet, you might get a wrong impression of what the Working Party was saying.
Yes. Well, certainly they do say, and they looked at at this point that it would be unrealistic to produce a definitive list of conditions that constitute serious handicap, and that's a point which the respondent makes in evidence, and we don't seek to contradict that. But whether our point is rather that some more precise criteria, either in legislation or in official guidance, is necessary for, at least for the in accordance with the law requirements.
You'll be coming back to this in that context. I think it would help me to have an idea, not what you say is the ultimately right definition. No doubt there might be different approaches, but examples of the kinds of approaches which you say would solve the in accordance with the law problem. Thank
you. And I should say finally, the other source of professional guidance is the BMA guidance, which is quoted on page 143 of the supplementary bundle in Professor Tilliger-Nathan's witness statement. And
so sorry, which page did you say?
143.
Yeah. And the extract is at 144. And this is the full extent of what the guidance says on this issue. The only point that we draw attention to at this stage is the point that in the third tirade on 144, the suffering. So one of the factors to take into account on seriousness is the suffering that would be experienced by the child when born, or by the people caring for the child, which isn't in the RCOG factors, at least expressly, and one may debate whether it's whether that's a fair characterisation of the legislation or not, but we are where we are. There's nothing official, and the professional bodies are left to make what they can of this broadly worded legislation. So I turn then to my first ground of appeal, which is interference with Article 8 rights. Yes.
And the appellant's submission in a nutshell is that the effect of section 11D, taking into account the features that I have highlighted, its broad and vague wording, the absence of safeguards, etc., its effect is to stereotype life as a disabled or seriously handicapped person as not worth living, and certainly as having less value than life as an able-bodied person.
Hang on 1 second. Yes, thank you.
Thereby impacting the feelings of self-worth and self-confidence of disabled persons, such as Ms. Crowter.
Say it again, thereby
impacting upon the feelings of self-worth and self-confidence of disabled persons, such as Ms. Crowter. Now, I don't intend to paraphrase, but I'm going to show you the legal test and then some extracts from the evidence to show why we say we meet the legal test.
Koppel, before you embark on that, could I just see whether there might be some groundwork that needs to be laid before you consider the question of interference? The rights under the Convention, in this case, the right under Article 8 regarding respect for private life, is a right that belongs to everybody, regardless of any question of disability. The case that I understand you to put is that something that you will go on to say impacts upon feelings of self-worth and equality, engages that right. I think you would be in agreement with that. So do we not have to lay that groundwork before going on to consider interference, or is it too obvious to need stated?
I fear it may be too obvious for me.
Well, even if it is, it's important to state it and to analyse it. One of the problems, as we all know, with Article 8, or maybe not a problem, but one of the features of Article 8 is that it talks of essentially private life, but that is given a very much extended meaning in the case law, which everyone now understands and accepts. There are various strands to it, such as privacy and family life and so on. But what is the strand that is engaged here?
So it's private life, and it's an aspect of private life which I will show you from the legal test. Can I take you to the legal test which I say we have to meet, and that may answer.
Yes,
I
interrupted you because I'll want to understand also from Ms. Smith when it's her turn, as to whether there's, as it were, common ground that this is a right which is engaged, and the question then becomes, has it been restricted, interfered with, or however one cares to put it, which is what I think you were about to go on to treat.
Yes. 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 Let me show you the legal test, and I'll then see if I can do it better in answering my Lord's question. So one place in which one may find the legal test for this strand is Volume 2, tab 18. And it's the Levitt and Austria case. Which was a case about a publication which criticised people who survived the Mauthausen concentration camp. One sees that from the first paragraph of the headnote, and then the applicant's efforts to take action against that publication in the Austrian courts. The legal test is at paragraph 46 on page 1407. And it's under applicability of Article 8. The court has held that any negative stereotyping of a group, when it reaches a certain level, is capable of impacting on the group's sense of identity and the feelings of self-worth and self-confidence of members of the group. It is in this sense that it can be seen as affecting the private life of the members of the group. And the court considers that similar considerations apply in the incident case when it comes to the defamation of former Mauthausen prisoners who constitute a heterogeneous social group. So the strand is negative stereotyping reaching a certain level and thereby impacting on the group's sense of identity, feelings of self-worth and self-confidence.
So, I think the answer to my Lord's question is that the key concepts are self-worth and self-confidence. That's the aspect of Article 8.
Yes. Now, we say, and we say that the appellants gathered together and put before the divisional court, and the impressive...
Sorry, just before we leave that, I hadn't identified that precise formulation in your skeleton argument. Perhaps it was there, but another term one finds in some of the case law is dignity. Is that the same concept or a different one? Is that relevant here?
Yes, it is relevant. Groups.
All these terms, I appreciate, are fairly loose and slide into one another.
Yes.
But I just want to find the most appropriate label for how you're saying Article 8 is engaged.
Yes. Well, I do first and foremost rely on the words of the cases. I think in paragraph 22 of my skeleton, I quoted very similar words from a different case.
From Axu.
Yeah. And it's the same. It's effectively the same words. It's slightly more simply put here, I think. I don't quibble with dignity, but I found myself on the wording of the cases. We say that the evidence which we put before the divisional court, both personal testimony and academic evidence, and the views of the expert United Nations body, the Committee on the CRPD, and an endorsement of those views in the Supreme Court, amounted to a compelling case that the legal test was satisfied on the evidence.
Legal test for interference. You've been referring to the legal test. Could you just specify what it's the test for? Yes.
It's the legal test for interference with Article 1 rights. I mean, I hesitate slightly because, as you know, we have Article 14 as well, and the court in the case I'm just showing you is talking about applicability of Article 8 as opposed to interference with Article 8.1 rights, because it's a positive obligations case. So it's all...
Yes, well, I don't want to add a level of complexity to the situation, but it had seemed to me that one starts with applicability before going on to the question of interference. That it may be that one doesn't need to pause very long on applicability, but if that's not the right analysis, then this is your chance to say so.
Well, for Article 8, for the Article 8 claim, we say one doesn't have to pause very long on applicability.
No, well, the divisional court didn't pause very long if it paused at all, and that may have reflected the argument that was addressed to it, which is that it was an unspoken assumption that the article was applicable. But I just want to make sure that that is solid ground before we go on to consider what might be more difficult questions.
So,
Well, hang on. I take it, is that a yes? In other words, are you accepting that even if it's not a difficult question to answer, you say there is nevertheless a first question that has to be answered, is Article 8 applicable? Before you ask, has it been interfered with? Must be right, mustn't it?
yes, that must be right.
Thank you, that's what I thought you'd say.
In the sense that if it's not applicable, it can't be interfered with.
Right.
Yes, I give an example that if a third party who was not a disabled, a person with a disability, was to launch proceedings in objection to this particular legislation, then one might say, well, so far as that person is concerned, they weren't a victim, it doesn't apply. I don't mean to burden you with any assistance in advancing your case, but it does seem to be important for your client group, as it were, to establish that they come within the category of people who are entitled to complain before getting on to the question of whether their complaint is well-founded.
Yes. And thank you, my lord. And the part of the body of evidence consists of the personal testimony of Ms. Crowter, for example, as to how the legislation makes her feel, how it impacts upon her own feelings of self-worth. You've got her witness statements in the supplementary bundle. The evidence which was before the divisional court, we set it out in paragraph 23 of our skeleton, and you've got the references to the first-hand factual evidence of the first and what was then the second appellant, Ms. Lee Wilson. And you have evidence from Lord Shinkwin, which is quoted in paragraph 94 of the divisional court's judgment. Whereas he characterises it, the continued application, so I'm reading from paragraph 94 of the divisional court's judgment, the continued application of section 11D and indeed active promotion stigmatise disabled human beings before we are even born, because its specific purpose is precisely to prevent us from being born. We are life unworthy of life. So those are the personal testimonies. There is then academic research in this field, some of which is gathered together by Professor Shaw in her witness statement, which starts at page 203 of the supplementary bundle. Can I just ask you to turn that up, please? And at page 204, Professor Shaw explains her research expertise being in the area of stigma associated with intellectual disability and other stigmatised conditions. And she sets out the results of some research on the impact of legislation in stigmatising people with intellectual disabilities. And we rely on paragraph 5 onwards, and her conclusion at paragraph 9 on page 207 She refers to the evidence above showing tensions between outdated current legal provisions and pervasive societal attitudes, and there being a clear connection between negative messaging inherent in legislation such as Section 11D and devaluation and discrimination experienced by people with intellectual disabilities, including those with Down syndrome.
Where is the passage where she makes a specific connection and gives the evidence in support for the effect of Section 11D?
So I think that's paragraph 5.
Let me read that again. It's not, I'm not saying there's anything wrong with it, I'm just trying to understand it. It's not, in fact, a statement based on any research, is it? It's simply saying that she would expect, or in her view, the fact that Section 11D says what it says communicates a message that the lives of persons with conditions such as Downs are not worth living. I can understand why that would be her opinion, but it's not a research-based. We haven't gone out and asked lots of people with Downs or some other disability, what do you know about Section 11D and how does it affect you?
Yes.
The reason I'm pressing on this is because, as you know, the Divisional Court said there was no real evidence on this point, and I just think, therefore, we need to see exactly what the evidence amounted to.
Yes. Well, they said they didn't accept the evidence. They didn't say which evidence they didn't accept or why they didn't accept it.
Well, all right, we'll come back to the criticism. I'm just explaining why I'm interested in this point. It's not.
I understand, and
But the only event, I mean, it is basically paragraph 5. It's basically the second sentence of paragraph 5. Isn't it? And then the last sentence says, in very general terms, on the basis of my extensive research on public attitudes to people with intellectual disabilities, it's my, yes. So again, she's not, I think, talking about research on people with disabilities. It's more about public attitudes to them. Am I misreading it?
Yes. Well, I think then she goes on in paragraph 6 onwards.
Yeah, so
to address what the impact of that kind of messaging is upon.
Oh, yes, all right. Well, maybe we shouldn't be looking first at paragraph 5. Maybe paragraph 6 is the more important. Let's just look again at what's said there. Yes, thank you. I mean, that is, again, research about the awareness of disabled people of public attitudes to their disability, negative public attitudes to their disability. It's not about 11D specifically.
Yes, and going on to yes, and paragraph 8 equally is the impact of negative messaging, such as she says section 1.
But in a sense, you've skipped over 7, which is more specifically about this, which is the Emmerdale episode, and which obviously I've read the evidence. Yes,
Well,
thank you. Well, that's just been helpful. Please, again, don't misunderstand my questions. No. I'm not challenging any of this. I'm just trying to understand exactly what's been said and how far it goes. Yeah.
Well, absolutely. And one does have to bear in mind there are two separate questions here. There's the question of whether section 11D conveys a negative message at all. And secondly, if it does that impact upon the disabled, like Ms. Crowter? And that second question, and does it impact upon them in such a way as to interfere with their Article 8.1 rights?
Yes, right.
And that second question is certainly squarely addressed in Professor Shaw's statement.
Could you just answer this? There's certainly evidence which you've pointed to that people in Ms. Crowter's position perceive 11D as impacting on their sense of worth. Is that enough for you? Or do you also need to go on and show that in fact, in the world at large, 11D has an effect on people who may not have a disability? Because the sort of evidence that we're looking at here ranges across both questions somewhat, possibly mainly the first. Because the divisional court were considering whether 11D caused public attitude of stereotyping. Is that the right approach, and do you indeed need to be able to show that it caused or contributed? Or is the subjective feelings of people impacted enough?
Yes, the subjective feelings of the people impacted is enough. It is the wrong approach to ask whether section 11D causes specific acts of discrimination. And it's the wrong approach because that's not the legal test which one finds in the Strasbourg case law. It is the only answer which the respondent had to this part of our case. There is no evidence on the respondent's side saying Professor Shaw's wrong, or Ms. Crowter's exaggerating, or anything like that. No contradictory evidence at all. The respondent's case was a purely legal one. That unless we could show that there was some causation, some causative link with acts of discrimination against the disabled, then the claim couldn't get off the ground. And we say that is the wrong approach, and was unfortunately accepted by the divisional court. We do, and the evidence does strongly suggest that negative stereotyping in legislation does have an impact upon exclusion, discrimination, but we don't have to go so far.
Well, does it? I haven't seen that evidence yet. It's not what Professor Shaw was saying.
Well, I think that's what she says in paragraph 8 of the statement we were just looking at. Section 1.
But he says negative messaging such as that inherent within section 11D.
Yes.
I mean, it might be said, again, I'm just testing this with you, that what section 11D really does is reflect societal attitudes about disabled people, which are, we hope, improving, but still have a way to go. But doesn't essentially contribute to them. It's almost the wrong way around. You, what happened when, in 1990, when this legislation was passed, is that people regarded it as acceptable to have a differential scheme for abortion in the case of disabled unborn children. And that reflected, you might say, an approach which undervalued the lives of disabled people. And I have no difficulty seeing how that is put. But that the legislation itself created such attitudes or contributed to them isn't to any significant extent, isn't so obvious.
Well, we say the continuing application of that, let's assume that reflection of societal attitude in 1990, the continuing application of that does stigmatise, does stereotype disabled life as less valuable. We have the personal evidence, we have Professor Shaw, we have some other academic evidence referred to in paragraph 23, and the views of the Disability Rights Commission, which, as you know, preceded the Equality and Human Rights Commission. Section 11D reinforces negative stereotypes of disability and is incompatible with valuing disability and non-disability equally. Again, that is, we say, an expert view from the body which was tasked with the protection of disabled people in society. We don't have referred to in the skeleton, because it was given permission at the Court of Appeal at PTA stage, the witness statement of Ms. O'Sullivan. And I would draw your attention to that. I don't think I've got time to go through it now, but paragraphs 7 to 15 on page 411 to 412. And just to summarise her view, Mencap's view in paragraph 15 of her statement, she says that section 11D stands out as an offensive, anachronistic anomaly in the legislative landscape. It conveys the powerful message that a life with a disability is a lesser life, even a life not worth living. It should have no place in a modern inclusive society that values all people. So, well, the experts, academic, professional, people who work with disabled people from day to day are of one view about the stigmatising effect of section 11. The other important body of experts who takes that view is the Committee on the Convention on the Rights of Persons with Disabilities. And you see that on page 289 of the supplementary bundle. And this is a report of the Committee on the United Kingdom from October 2017, and paragraphs 12 to 13 on 280.
So where's the first page of
So,
this?
the first page is at 287.
Yes, thank you. Another time it'd be useful to have tabs in the bundle, because then one can find one's way around more easily. But you can help. Yes, thank you. Yeah.
So there's a process every so often. The UK, I think it's every 3 years, the UK reports to the committee on its efforts to comply with the convention. The committee then asks questions and then produces a report such as this. And at paragraphs 12 to 13 on 289, if I just ask you to read those paragraphs. And this is indeed the fourth occasion where the committee had recommended that a state amend abortion laws which provided for disability selective discrimination. The three other occasions you've got in the supplementary bundle in relation to Spain, Austria and Hungary. I'll just give you page references. If I may, 1469. No, that's not right. Sorry, it must be the authorities bundle. Sorry. It's volume 2 of the authorities bundle, 1469 for Spain, 1485 for Austria, and 1477 for Hungary.
So what was the Austria one?
1485.
Yeah, thank you.
And just so, again, just a reference to see this, the status of this committee, it's Article 34 of the Convention, which is in the Authorities Bundle, Volume 2, Tab 19, page 1444. And these are essentially experts.
Yes, thank you.
They aren't necessarily lawyers, but they are experts in the field of the convention. And then in volume 1 of the authorities bundle, at page 338, we're back in the Supreme Court, Northern Ireland Human Rights Commission. And paragraph 133 in Lord Manser's judgment the majority on standing and the majority on compatibility. You see the under the sideline section. Can I ask you to read that?
Yes, thank you.
So the notwithstanding the endorsement in the Supreme Court, or at least by Lord Mance in the Supreme Court, the Divisional Court rejected our attempts to rely upon the views of the UN Committee on the grounds that we were impermissibly inviting the court to apply new principles of international law, which weren't already inherent in the convention. That's paragraphs 104 to 106 of the Divisional Court's judgment. And we say that was an error. The purpose of pointing to the views of the committee at this stage of the argument was to support the appellant's factual case that section 11D has the necessary stigmatising effect, the necessary effect to satisfy the Article 8 legal test. And in the expert view of the committee, it does stigmatise disabled life, and we say that that was highly relevant to meeting the Article 8 legal test. And there's absolutely nothing untoward about relying on those expert views, just as there's nothing wrong with relying on an expert view of a domestic body. Here is a view which is directed to section 11D in terms which strongly suggests that the Article 8.1 test is met. Not what they were saying, it wasn't the test they were applying, but the expert view is entirely consistent with that test being met.
So the AB line of authority says it's a complete red herring, because that's to do with the use of international conventions, international materials in substitution for our law.
Yes.
And that's that we shouldn't be doing.
Yes.
But here you were just seeking to produce evidence.
Yes, and now of course I accept when I come to justification, and I rely on the CRPD in the context of justification, the AB line of reasoning is closer to the mark, and I have to deal with it there. But at this stage of the argument, it's a matter of evidence which we say the Divisional Court should have accepted. I think that's all I want to say about Article 8.1 and Ground 1. What is now Ground 2, that's paragraph 30 of our skeleton argument, is Article 14, and we say it must follow if there is an interference with Article 8.1 rights, then we are within the ambit of Article 8 for the purposes of Article 14. But even if there isn't, even if the degree of impact of Section 11D upon the appellant's interests is insufficient to trigger Article 8.1, we say that we are still within the ambit of Article 8 for the purposes of Article 14. Legislation such as this is capable of affecting the relevant interests, even if you conclude on the facts or you conclude that the Divisional Court was entitled to say that it doesn't in this case. In accordance with the law, then, ground 3, could I ask you to pick up my supplementary skeleton argument? So, if ground 1 succeeds, and there is an interference with Article 8.1 rights, then the next question is Article 8.2, is the interference in accordance with the law? In accordance with the law, then, the principles, say, are familiar. We've set out in paragraph 4 of the skeleton, of the supplementary skeleton, the bridges expression of those principles, bundle 1, tab 15, page 431. And then we go into more detail on the different aspects of in accordance with the law. And the first point is that in paragraph 5 of the supplementary skeleton that, as ever, context is everything, and the level of precision, the degree of safeguards and so forth, which are necessary to satisfy in accordance with the law, will depend upon the context. The content of the instrument, the field is designed to cover the number and status of those to whom it is addressed. And you also see reference in Bridges at paragraph 82 to there being a relativist principle. So the more significant the interference, the more that needs to be done by way of satisfying in accordance with the law. And we say, in terms of the implications of the context, we say from paragraph 7 onwards that the context requires a relatively high degree of legal precision to comply with in accordance with the law in this context. And that is for essentially 3 reasons. First of all, because we are here concerned with the circumstances in which a human life may be ended, and I call it a human life advisedly, because a viable fetus was described as having human life in the St George's case, which we quote in paragraph 7.
I mean, Mr. Cobble, is it really necessary to debate that question? Isn't the underlying uncontroversial point that it's a matter of extreme seriousness?
My Lord, I'm happy with that. It is a matter of extreme seriousness, in part because abortion is a matter of extreme seriousness, and an abortion of a viable fetus in particular, but also because we're talking about the criminal law. And it doesn't seem to be common ground, and hence we didn't include the Nicklinson judgment in the authorities. That, as we set out in paragraph 9, a high standard of clarity and precision is required of any law defining the elements of a criminal offence. And we cite the BPAS case, paragraph 10, as authority for the proposition that applies in the very context of Section 1 of the 1967 Act. The only point then that's left under this section of the skeleton is paragraph 8, where we acknowledge that the circumstances in which viable human life may be terminated raises sensitive and controversial issues. And the thrust, at least, of the defendant's submission is because it raises sensitive and controversial issues. That is somehow a good reason for leaving it broad, leaving it vague, leaving it up to individual doctors to take the decision as they see fit in the privacy of the treatment room. But the authority, we say, on sensitive and controversial issues is to the opposite effect, and that's the Purdy case on whether the DPP ought to have a policy on prosecuting people for assisting in suicide. And just to show you the reference that we've made in paragraph 8, it's bundle 1, tab 8.
Of course, we'll go there if you want, but you have actually set out a
Yes,
key passage, haven't you?
I've set the key passage. Yes.
Not stopping you, but I just think it's a straightforward submission, which, speaking for myself, I fully understand.
Well, I'll leave that there. Thank you. So that is the relevant features of the context. The Divisional Court rejected this aspect of our case in reliance upon the authority of Bright. So see paragraph 112 of the Divisional Court's judgment. But we say the Divisional Court didn't apply the legal test in Bright. So Bright is bundle 1, tab 9. You see the essential facts in the italicised headnote on page 157. It was a case concerned with prison policies in relation to separating prisoners who were in a homosexual relationship. And in paragraph 29 on page 169, we see the paragraph which the Divisional Court relied upon. Can I ask you to cast your eye over paragraph 29, please?
Yes.
But then the Divisional Court goes on to say, in some contexts, it's neither impossible nor even very difficult to define in advance the way in which discretion will or may be exercised. And then you need a clear statement of how discretion will or may be exercised. If that is absent, shortcoming may not be made good by the fact that the decision is susceptible to challenge adversarial proceedings. They go on to say, just at the bottom of that paragraph, where the statement as to how a discretion will or may be exercised is as precise as is practicable in all the circumstances.
So sorry, where are you reading from?
I'm sorry, I'm at the bottom of 169.
Oh, I see.
After the reference to Lieven.
Give me a moment. Yes.
Where the statement as to how a discretion will or may be exercised is as precise as is practicable in all the circumstances. That a decision may be challenged in adversarial proceedings provides the important safeguard against arbitrary decision making that is required by in accordance with the law. So you may have a context where it is very difficult to have precision, and in those circumstances, Article 8 doesn't expect the impossible or the impracticable. But if that is the case, you still need provision which is as precise as is practicable in all the circumstances, and then the additional work in complying with, in accordance with the law, is done by the opportunity for legal supervision and legal challenge.
So that was those observations were made in the context of a case. I'm not talking about the authorities, which were largely to do with national security issues, but the context for Bright itself was considering what was going on in a relationship between two prisoners and what the consequences were one way or the other of them being together or apart. And that, they say, complex and difficult to assess. Your point, as I understand it, is that that can't be taken as justifying making no effort to achieve some sort of framework.
Yes.
Within which, well, whether one better calls it a judgment, is to be exercised.
Yes, yes, absolutely. My submission is, of course, the in accordance with the law criterion does not require the impracticable or the impossible, but it requires such precision as is practicable in all circumstances. And the divisional court simply didn't consider at all whether the 1.1d regime is as precise, is as structured, foreseeable and so forth, as is practicable in all the circumstances. And simply saying, as they did in 111 to 112, well, there are situations in which precision is impossible, was not a sufficient answer. And in a sense, my job on this aspect of the case ought to have been relatively straightforward. It's a pressing context. It's a serious matter. The terms used in the legislation are broad. They are subjective according to the professional body. They use language which nobody uses these days, and there is no official guidance. There's nothing. No other law in Strasbourg terms to guide the way in which it is applied by doctors.
I asked you earlier, what sort of provision do you say would be necessary to satisfy the in accordance with the law requirement? Are you saying there should be a definitive list of conditions?
No, I'm not saying there has to be a definitive list of conditions. As a minimum, there ought to be statutory guidance as a bare minimum. It is not sufficient to have just section 11D and nothing underneath it in terms of law, and that's without me having to say anything as to what the guidance ought to say. That's the bare minimum.
Well, why? Unless you say something about what the guidance ought to say, it's a bit hard to see why it's necessary to have guidance.
Well, my Lord, I first of all, I disagree with that respectfully. Even if you take the view that the RCOG have got it absolutely right and have said all the right things, what they say is not law in the Strasbourg sense.
But would statutory guidance be law?
Yes.
I'm sure you're right about this. I would just like to be shown the Strasbourg case law, which says that guidance from a professional body can't help in can't help supply a gap in required by law. Is there an authority you're immediately aware of, or what is it to?
There is authority, but I'll need to go away and think about that, if I may. But then, in terms of what the substantive content of the law ought to be, again, there are a number of different levels. There must be a resolution to the very significant ambiguities which the RCOG has identified. For example, is this section seriously to cover a condition which manifests itself at age 50 or age 60? Is it seriously to cover a condition which is correctable through surgery? At the moment, on the face of the RCOG report, it is a legitimate view for a doctor to take that a fetus with a club foot has a serious handicap, at least until the surgery is done and that is correct. So at the very least, those sorts of ambiguities need to be rectified. We have stronger, more detailed criticisms and in terms of the treatment of Down syndrome, which is a particular concern to my client. But both under this head and under justification, my case is that the law doesn't do enough. I don't have to show, I don't have to persuade you that there is a particular form or particular words that the law ought to have. It is manifestly insufficient for in accordance with the law, and it is overbroad when it comes to proportionality. How then Parliament addresses that?
I mean, just suppose it didn't use the language which, as you say, is outmoded and regarded by many as offensive, of seriously handicapped, and used more up-to-date language. One possibility would be seriously disabled. Now, the real problem about uncertainty would be what is meant by seriously. I think most people have a concept of what's meant by disabled, and indeed, in principle, there are definitions in the Equality Act which could or might not be used. But the word seriously is obviously important. Isn't that always going to involve an element of judgment, questions of degree, which have to be made on a case-by-case basis? Yes, there will always be some judgment involved. But
me give you another point on that issue. One of the criticisms which the appellants have of the RCOG attempt to elucidate seriousness is that it invites doctors to consult with other clinicians, doesn't invite them to consider the condition from the point of view of people who care for those with a condition, who live with the condition, the social aspect, as it were, of seriousness. Professor Jackson, second statement, supplementary bundle 192, criticises what she characterises as the purely medical approach taken in the RCOG report to seriousness. Take another issue, substantial risk. We've set that out, paragraph 11(2) of our skeleton argument of the supplementary skeleton, the Supreme Court authority on the two different meanings of substantial. In some legislation it means present rather than illusory or fanciful. In some legislation it means important or weighty. No elucidation, no guidance, no case law, nothing to tell doctors which meaning of substantial is intended in this case.
The difficulty might be thought to, this discussion may be thought to show, is that when one's considering the parents who are faced with a situation of this kind, with whom the doctors are concerned and whom the doctors have to either say that the test is satisfied or not, is that they may have very different views from one family to another as to what is serious. So if you're saying we shouldn't medicalise it, then that may very, very well be right. But what is for one family a serious or a significant matter may be viewed differently by another family. And so there are in some areas of the law perhaps a need for ambiguity as a positive and not simply as a negative.
Well, my Lord, I absolutely accept what you just said to me, but there are two different approaches to that. You've got the current approach, which is to use just very broad terms and then leave it to doctors to assess seriousness as they see fit. The alternative is to have a definition, either in legislation, in subordinate legislation, potentially in guidance, and to actually tell doctors, and you shouldn't just take a medical approach. You need to consider the issue from the perspective of the.
So that's not a definition. On that basis, the definition might still be seriously disabled, but you're talking effectively about statutory factors to which the doctor should have regard in reaching a decision on seriousness. That would be, you could legislate in that way. I've seen it done. Is that what you mean by that? That's not a definition, but that's, as it were, statutory factors to which regard must be had.
Yes. Yes. So there is a difference between a definition, and the RCOG has a definition, and then factors which go to what the definition is. Oh, sorry, to whether the definition is satisfied.
We're all familiar in different statutory contexts with a very broad principle, and then a checklist of factors to take into account in understanding how that broad condition is satisfied. Yes.
So the factors that might be listed. In this case, they might include the not purely medical. Look at the BMA in contrast to the RCOG, the burden that may be imposed on the people caring for the individual. It might include that, it might not. It might include the burden on society of caring for the individual, which the RCOG say is relevant. My clients would dispute that. But these are all issues that the law simply does not grapple with. It simply leaves it all up to individual doctors. And it leaves it up to individual doctors in circumstances where there is no real prospect, a realistic prospect of supervision of the decisions that they make. So the majority of the reasoning of the Divisional Court on in accordance with the law, paragraphs 109 to 110, was addressing a point that I had made on an old case, the Peyton case in 1979, and the comments of the President of the Family Division in that case that it would be, he said, quite impossible for the courts to supervise the operation of the Abortion Act 1967. And the Divisional Court in paragraph 110 goes some lengths to distinguish or downplay the significance of that, we say, entirely correct characterisation, and pointing out that between G and H that there can be prosecution of doctors who have not acted in good faith. And there is one example of that, the Smith case. But a theoretical possibility of challenge, and it is theoretical, it's once in 50 years, the RCOG themselves say it's not going to happen. An entirely theoretical legal safeguard is insufficient for the purposes of in accordance with the law. And that is paragraph 22 of our supplementary skeleton, and the best authority we think on that is the Gillen and United Kingdom case at bundle 2 tab 9. Again, I shan't go to it, but finding in relation to stop and search powers in that case not in accordance with the law, because although you could have a legal challenge, it would be extremely difficult to succeed given the breadth of the criteria.
Is prosecution the only method of regulation? For example, this is a genuine question, because I don't know what the law about this is. Would the guidance of the RCOG be judicially reviewable?
I don't believe that it would, my lord. The RCOG has no statutory or other public law footing.
No, but the law's a bit fuzzy about that. There are circumstances in which non-statutory bodies should nevertheless be judicially reviewed, but I can't remember exactly where the line is drawn.
Playing some kind of role, some kind of surrogate. Well, that
I know what you mean. Yes.
There are instances in the evidence of doctors being struck off for improper professional conduct in the context of clinics.
That is theoretically possible.
No, I'm just recalling that somewhere in the evidence are descriptions. It may be Dr. Argent, I can't remember, of individuals who were in fact disciplined by their professional bodies
may have been in Mr. Argent's first statement potentially. It can happen. The RCOG says explicitly it's not giving ethical guidance. There is no ethical guidance on the subject, but in theory, yes. In practice, one would still effectively have to show bad faith. And it's one thing to say, well, theoretically, yes, if there is bad faith, then the courts can intervene, or there can be a prosecution, or the professional body can intervene. But what if a doctor is just mistaken? Just is taking too broad a view of what amounts to a serious handicap? How can that possibly be challenged? An extremely broad view in good faith. No way of
Just remind me where the bad faith requirement comes from.
So that is in section 1.1. Yeah, section 1.1, the first bit of section 1.1.
Yeah, of course, yes, it's there. Yeah, thank you.
The Secretary of State's response to "in accordance with the law" is that we are asking the wrong question. They say they say in their supplementary skeleton that we are illegitimately addressing "in accordance with the law" from the standpoint of pregnant women, or of doctors, or of the unborn. They say, paragraph 6 of their supplementary skeleton, rather than from the point of view of the appellants, whose complaint is about negative stereotyping of disabled persons. And we say that criticism is misplaced for 3 reasons. Firstly, the interference in this case is caused by section 1.1d. It is section 1.1d. That is the legal basis for the interference, and the correct question is whether section 1.1d is law, quote unquote, in the Strasbourg, in the Article 8.2 sense.
Well, I wonder, is that? We'll obviously hear from Smith, isn't it? Not Smythe, from Miss Smith in due course on this. But isn't the interference caused by the fact of there being a differential approach to people with fetuses with a serious disability, as opposed to fetuses without such a disability? And that is what creates the perception that people with disabilities are undervalued. From that point of view, the details of the law don't really matter, do they? The so-called defects, all the ways in which you're challenging the law, are beside the point. But what creates the perception is the fact that there is a differentiation.
So,
I think that's Miss Smith's point, and if it's not, she won't adopt it. But help me on that.
So it's not beside the point, it is at least part of the point. The point is not simply that there is a difference of treatment, but that the regime which permits termination of disabled fetuses at a time when it would be a criminal offence to terminate a non-disabled fetus. The regime is overly broad, vague, leaving excessive discretion to doctors.
I thought the point was that,
safeguards.
that the means by which one differentiates between the two classes is insufficiently clear to be in accordance with law. It's not what happens within the two, but it's drawing the line. Isn't that your complaint?
It is drawing the line, my lord. Although that does still entail consideration of how the line is drawn. The line is drawn by doctors with no elucidation or guidance or limitation.
But the point I'm seeking to make is that it's not just that there's a difference, which takes you so far, but that who decides and how they decide where the difference is to be drawn.
It is part of the complaint.
Yes.
Yes. Yes. And all of those defects, we would say, contribute towards the stereotyping effect, towards the message. And in particular, and thirdly, in particular, there is no. Sorry, I think I didn't do second. There is no distinction to be drawn between the position of the appellants and the position of the unborn, which is part of the criticism which is made, because the very complaint is that the treatment of the disabled unborn has the effect that the effect of negative stereotyping, etc. The other.
Sorry, yes, you said you had 3 points.
Yes,
and the first one I brought down, that the interference is caused by 1.1d, that is in effect the interference.
Yes. Yeah. And then I think my second point was the point which my Lord Justice Peter Jackson was putting to me, that it's all the defects.
For broad order's sake, just
so
give it to me again.
The defects, the breadth, the vagueness, the lack of safeguards go to the drawing of the line between the disabled and non-disabled, and that is an integral part of the complaint. And then, thirdly, certainly no difference between the appellants and the unborn, because it is the treatment of the unborn which conveys.
Sorry, again, I was doing it too slowly. What was the third one?
Third one is that there is certainly no distinction between the position of the appellants and the position of the unborn. So part of the Secretary of State's criticism is you're illegitimately looking at this from the point of view of the unborn. But again, that's a distinction without a difference, because it is the treatment of the disabled unborn which has the negative stereotyping effect. Proportionality and justification. And I take Article 8 and Article 8.
This is ground 4.
Ground 4, yes, I'm sorry. I take Article 8 and Article 8 read with Article 14 together. The key conclusion of the divisional courts, and one gets it from paragraph 134, final sentence, and on Article 8 and paragraph 144, final sentence, this is within the margin of discretion. It's for Parliament. Now, the Divisional Court sets out the different stages of the justification test, paragraph 113, and we are concerned with stages 3 and 4, less intrusive measure and fair balance between the rights of the individual and the general interests of the community. And what we say in a nutshell is in paragraph 55 of our skeleton argument, our main skeleton argument. And it is that section 11D does not strike any kind of balance between the interests of the pregnant woman, the rights and interests of the viable fetus, and the rights of disabled persons more generally. So it's all one way. Abortion very widely available on grounds of disability right up to the point of birth without meaningful safeguards. We say it doesn't strike a fair balance. So where did the Divisional Court go wrong? We submit, firstly, it went wrong in its approach to the margin of appreciation, margin of discretion, and secondly, it went wrong in applying, in conducting the balancing test in the light of the margin of appreciation. Paragraph 123 of the Divisional Court is margin of appreciation, and the Divisional Court makes a finding that there is a broad margin of appreciation, a wide margin of appreciation, because there is no international consensus in the Council of Europe. They say, first, whatever the precise number of states that permit abortion on grounds of fetal abnormality, there is no international consensus in the Council of Europe on this sensitive issue. They say, accordingly, it is clear that the European Court gives a wide margin of appreciation in this context. And we say that that statement of approach is incorrect, is wrong for two reasons. Firstly, there was an erroneous approach to identifying consensus. What the Divisional Court appears to mean by consensus, and I say this because of the language of whatever the precise number of states, they seem to have been looking for a common view amongst the contracting states.
When you say common, do you mean uniform?
Uniform. They don't actually say what they think the standard is for consensus, but I understand, I make that submission because of the words whatever the precise number. Now, we say it is clear that unanimity is not necessary. That's paragraph 36(1) of our skeleton. We cite the Goodwin case, where the court attached less importance to the lack of evidence of common European approach than to the clear and uncontested evidence of a continuing international trend.
Remind me what the issue in Goodwin was.
Goodwin is the case about whether transsexuals should be able to change their legal documents so as to reflect their acquired gender. And just to give an example of what Strasbourg, or how Strasbourg approaches consensus, in the ABC and Ireland case, Bundle 2, tab 11, it starts at 1077. And this is the case about Irish law, a restrictive Irish law on abortion, which required women and girls to travel to the UK to obtain an abortion. At paragraph 235 on 1138. So I should start with para 234. The question remains whether this wide margin of appreciation is narrowed by the existence of a relevant consensus. 235, in the present case, contrary to the government's submission, the court considers there is indeed a consensus amongst a substantial majority of the contracting states towards allowing abortion on broader grounds than accorded under Irish law. Then the court cites abortion on demand in 30 states, abortion on health and well-being grounds in approximately 40 for the first applicant and 35 for the second applicant. Out of, certainly now it's 47 Council of Europe states, it may be one or two less at that point. Now, in that case, 236, notwithstanding consensus, that didn't decisively narrow the broad margin of appreciation for the reasons subsequently given. But consensus is not unanimity, we would say, and on an ABC and Ireland type approach, we say there was sufficient evidence that the preponderance of legal practice amongst the member states ran counter to the effect of section 11D. So you've got the evidence of Council of Europe practice is in the statement of Ms. Duncan for the Secretary of State. I'll just give you a page reference. It's 127 of the supplementary bundle, where she lists 16 out of 47 states which permit abortion on grounds of fetal disability without time limit. And of those, there was no distinction drawn between those requiring proof of serious risk to health or well-being of the pregnant woman. So one can't be sure that they were analogous to section 11D. And the second error that we say the divisional court made in paragraph 123 is apparent from the use of the word accordingly. because it does not follow from absence of consensus, let's assume there was no consensus, it does not follow automatically, accordingly, that there is a wide margin of appreciation in Strasbourg terms. On the contrary, there will be a number of factors, say a multifactorial approach to be taken. See paragraph 36, 3 of our skeleton argument. And we point to a number of factors which ought to serve to narrow the margin in Strasbourg terms in this case. The disability discrimination context is one, and we cite from the Guberina and Croatia case. I don't need to go to it because you've got the quote there, but it's in bundle 2 at tab 17. Disability discrimination gives rise, that was a case of disability discrimination. It gave rise to a substantially narrower margin of appreciation. And we say one might also expect the margin to be narrower in the very serious context that we are concerned with.
Do we not have to bear in mind that the result of the decision of the divisional court on the other issues which are not appealed, or don't have permission to appeal, this is not a case where the terminations, any terminations pursuant to 11D themselves involve any breach of the convention. So that what we're concerned with justifying here is legislation which, as regards the people most immediately affected by it, are lawful, but which interfere with the Article 8 rights of people not immediately affected by it, because of the message which it is sent to send out. I think there is a risk, which I just noticed particularly in that last point you were making, of slipping into thinking what we have to justify is the actual direct impact of the legislation on either the parents or the unborn children, whereas we're concerned with victims who are at one remove, in the way
Yes.
In the way that you've explained their rights are still engaged. Is that relevant to the strength of the justification that is required?
Well, first of all, my Lord, I agree with the point you put to me. We are concerned with the appellant's rights, although I would say that...
Yeah, sorry, I was putting, that's assuming you succeeded up to that point,
yes.
Of course. Yeah.
Those rights are not as pressing as the right to life that we previously relied upon, but nevertheless do go to a significant aspect of their Article 8 rights. So, so this isn't a case about social security benefit not being paid as much money as you might have done if you had a different status. This is legislation which goes to a fundamental aspect of their self-worth, self-confidence, etc. But the correct exercise for the court, I agree, is to balance, see 113 paragraph 4 is of the divisional court, is to balance the rights of the individual against the general interests of the community. And the rights of the individual are my client's Article 8 rights. Now, as it happens, when the divisional court came to conducting the balancing exercise, it seems to have overlooked my client's rights, as they're not mentioned as a relevant factor. Also, the rights and interests of the fetus are not irrelevant to this exercise. They are part of the public policy consideration. They are part, at the very least, of the general interests of the community. I once saw, for example, Lady Hale in the Northern Ireland case, referring to the community's interest in the protection of unborn life. So one can't exclude the context and the fact that we are talking about circumstances in which human life is terminated.
I see the time.
I see the time.
Would that be a convenient moment? Approximately how much longer do you think you're likely to be?
20 minutes. I'll try and...
Does that create any difficulties for you, Ms. Smith?
My lord, no.
No. You might just consider with Ms. Crowter over the adjournment whether she does wish to say anything herself in addition to your excellent submissions. I can, of course, understand why she may wish to do so, but she can be assured that we have read her witness statements, and in my case at least, followed the link to the YouTube video that she gave us, and we are very alive to the human background. I'm sure she knows that, but it needs to be said. But these are ultimately, despite the important human background, issues of law.
I shall endeavour to explain that to her.
Thank you.
I'm going to